You've also asked about the substantive defenses that a tenant may have. Obviously, the very first substantive defense is that the tenant may not have engaged in the behavior for which the landlord is seeking to evict. For example, the tenant may have actually tendered the rent, and the landlord may have refused to accept it and then seek to evict for non-payment. That is not non-payment of rent. Or the landlord may be claiming a breach on the part of the tenant, and the tenant may deny that he or she engaged in that behavior. So one substantive defense simply is that the tenant has not violated the lease. Another common defense to evictions is landlord retaliation. Texas law protects tenants from retaliation for a period of 6 months from a period of exercising a right under the lease or federal law or state law or local ordinance. And if a landlord seeks to evict a tenant in retaliation for a tenant having exercised a right under the lease or federal law or state law or local law, then the tenant has a defense to an eviction. Now, this can get into somewhat muddy waters here if the landlord has a partially legitimate reason, but is also motivated in part by retaliation. And the law here isn't very clear on what the outcome should be. Suffice it to say that from a tenant's perspective, if the landlord is motivated in any way by illegal retaliation, then the tenant should raise retaliation as a defense. And in my mind, a better outcome or decision by a judge would be that because the legislature has said retaliatory evictions will not be tolerated, that the judge should not allow a landlord to win if the landlord is motivated in whole or in part by a retaliatory eviction. Another common substantive defense that is available is the waiver defense. And this is especially true in eviction cases for non-payment of rent. And waiver can take two forms. One, you may have a waiver defense in a case where the landlord has consistently accepted rent late and not given you warning that late rent payments will no longer be accepted, and then simply proceeded to give you a notice to vacate for late payment of rent and files an eviction lawsuit. In that case, if you show the court that you tendered the rent for that month at approximately the same time that you've always tendered the rent, that the landlord has previously accepted rent that late in previous months, and not giving you any warning that late rent would no longer be accepted, then you have what's called a waiver defense to the eviction. But you will need to explain that to the landlord or to the judge, and you will have to prove to the judge that the landlord has previously accepted such late payments. And if you do that, then you may have a valid waiver defense which will prevent the landlord from obtaining possession of the property. Another, or the second instance of waiver, is when you actually pay the rent after receiving a notice to vacate and the landlord accepts the rent. Or you pay the rent after receiving the eviction papers and the landlord accepts the rent. If the landlord has done that, then you want to assert in court that the landlord has waived the right to proceed with an eviction by accepting the rent. Where you can sometimes run into problems is that some landlords will actually take the rent payment and hold the check or the money order and not cash it, and argue to the judge that they have not actually accepted the rent payment. And that can be a muddy area of the law. Again, that's not perfectly clear, but you would certainly want to bring it to the attention of the judge that rent has been paid, and argue to the court that by taking your rent, even if it hasn't been cashed, that the landlord has waived the right to evict you for not paying the rent for that month because the landlord has accepted the rent. Another defense of which you should be aware is the illegal discrimination, and this can come into play during the lease term. As you know, Texas law and also federal law prohibits landlords from discriminating against individuals on the basis of their race, ethnicity, sex, disability, family status, or religion. And if a landlord seeks to evict someone or non-renew a lease of a tenant on the basis of one of those protected categories, then that is illegal, and you have a defense to the eviction, because the landlord cannot refuse to renew a lease or terminate a lease based in significant part on illegal discrimination against someone who may happen to have a disability, or someone who may happen to be a particular color, or someone who may happen to have children. A final substantive defense of which you should be aware of it as a tenant is a landlord's unclean hands. To the extent that the landlord is seeking to evict you for something that the landlord may be partially responsible for causing, you may have a defense to the eviction. For example, if a landlord fails to make a major repair and you have been forced to make the major repair yourself and are unable to pay the rent, you may have an unclean hands argument, even though under Texas law you as a tenant cannot withhold rent because of a landlord's failure to repair. The most common, or the cleanest unclean hands argument, if you'll excuse the pun, is the case in which a landlord refuses to accept the timely payment of rent and then turns around and seeks to evict the tenant for non-payment of rent. In that case, the landlord has caused the non-payment of rent, has unclean hands, and is not entitled to prevail on eviction for non-payment of rent. There is one final substantive defense that sometimes comes into play, not that often, but it is something of which you should be aware, and that is the statute of limitations. If more than 2 years have passed since the incident for which the landlord is seeking to evict you, you have a defense under the Texas statute of limitations. A landlord must file an eviction lawsuit within 2 years of the alleged breach on your part. Now, this is not something that you're going to see very often, but I have seen cases where landlords have actually tried to evict or given notice of termination of a lease to a tenant and listed many reasons for the alleged eviction and gone back several years. So to the extent a landlord is seeking to evict you for incidents that happened more than 2 years ago, one of the things you would want to tell the judge in representing yourself is that to the extent the landlord seeks to evict for actions more than 2 years old, the statute of limitations bars those claims.